Member from Oak Bay, Gordon Head.
Thank you, Honourable Chair. It gives me great pleasure to rise at committee stage for this bill. As the members are aware, this is a rather novel process and procedure here, so I hope members will bear with me, as it might take slightly longer than usual. The Minister of Finance is here with her staff. Unfortunately, or fortunately, I'm not able to communicate with her staff. I may have to ask questions of the Minister on technical nature with respect to the broader Business Corporation Act, in which case she would respond to the question via information from her staff through consultation with them. My staff, Sarah Miller and Stephanie Sidden, are back there in the public gallery, and I may have to walk over to them to chat with them in the public gallery because they're not able to be present behind us. This is interesting. We're sort of breaking new ground here, and so I thank everyone for their indulgence as we move forward.
Shall Section 1 pass? On Section 1, member from Vancouver, Langara.
Thank you, Mr. Chair. Well, just with those words of introduction by the member, I'd just like to ask if we can just have a general understanding in terms of this particular bill and the way that it was drafted. What model was used for the purpose of this bill?
Member from Oak Bay, Gordon Head.
Could I start by asking for a clarification as to what the member means by the term model?
Member.
Well, for example, the other word could be used as precedent.
Member from Oak Bay, Gordon Head.
Thank you, Honourable Speaker. Right now in Canada, there are no other provinces that have benefit company legislation. So in essence, there is no precedent in the Canadian context for which this legislation is based.
Member.
Were there any other precedents used from any other jurisdiction?
Member from Oak Bay, Gordon Head.
The process involved in the drafting of this bill was extensive over the period of about 2 years. We started initially, the issue was brought to us by members in the business community who were concerned that there was no avenue for which they could incorporate to recognize the direction they wish their company to go. In British Columbia, the member will be aware that we have the C3 networks. We were brought to us by small business that in fact this does not work for some of them because of the asset lock associated with the community, or the C3s. And so we essentially drafted this through extensive consultation with independent lawyers, with third-party advocates, with business community. We held stakeholder engagement meetings in Vancouver several times, and we worked through the legislative drafters. In the legislation, there was our legislative drafter assigned to us, put the draft together. We had many iterations of that. We worked through the Ministry of Finance to get feedback from the Ministry of Finance as well. They too had comments that we tried to incorporate, and that led to the bill that is before us today. The member will recall that I first introduced the bill last spring and left it on the order papers for a 6-month period. It died on the order papers in the end of the fall session. The goal of doing that was to gather feedback from broader stakeholders to ensure that we were reflecting that feedback in this particular bill.
Member.
So thank you for that response. In terms of the level of consultation, can the member please just provide some further detail around the types of groups and the level of response and feedback that was received?
Member.
Thank you, Honourable Chair. Over the past year, we consulted with a number of stakeholders, as I mentioned, including business leaders, owners of C3s. It was very important to us that the C3 community was supportive of this direction we're proposing. We met with stakeholders in that community, both C3 businesses as well as some key advocates who were involved in advocating for the C3 business model here in British Columbia, as well as lawyers. We also consulted on the legislation in the fall of 2018 with lawyers from the Canadian Bar Association in particular to ensure that it fit well within the Canadian law context. We met with several academics at various times, and we had roundtables with business owners several times, twice actually, and a few dozen people came in that regard.
Member.
Well, I think it's important, of course, in this process. We have also heard, as a BC Liberal Caucus, from members of the community who have specific considerations, which we'll be talking about during the course of the review of this bill, section by section. But just with that in mind, from the time that this original bill was tabled in the spring session, what changes and what considerations have been made to the original form of the bill versus this current one?
Member.
Thank you, Honourable Chair. The bill refines the previous version of the bill introduced last spring to better fit into the current statutes. We took the last draft, the one that the member referred to, we took that into consultation. We sent it to the Canadian Bar Association to get feedback from them. It removed the requirement. The key change was that we removed the requirement for benefit companies to change their name, as the feedback we got from stakeholders was this would be viewed as cumbersome and a significant barrier to adoption. There were a few subtler changes that were made with respect to the role of the duties of acting directors, slight change there, and also another small change with respect to section 157. Yeah, 157, I believe it was. Yes, here it is, section 157, under section 7 of our act here.
Member.
So in terms of the considerations about this bill, it's been said, of course, that B Corp original framework comes in the U.S. context. So what differences are in this current bill that is different from the B Corp model?
Member.
This bill does not refer to B Corps in any way at any time. The B Corp is a third-party verifier of benefit companies in the U.S. context. So there is no reference of B Corp in this legislation.
Member.
So we will certainly talk about the necessity of having a third-party standard setting body when we get to Section 5 of the bill. But in terms of the actual framework in the U.S. context, what differences are there between this legislation from similar legislation in the United States?
Member.
So I developed with consultation with staff, ministry, stakeholders, legislation in the context of Canadian law and in British Columbia law. We did not focus on U.S. law, so I am not able to answer the question to the member's satisfaction, because I have not, nor did I base this on anything to do with U.S. law.
Member.
So again, well, let me reserve the question then, I think, in terms of standard-setting bodies to that particular section. In terms of any other considerations around how benefit corporations would work in Canada, were there any tax considerations that were driving part of the drafting of this bill?
Member.
Tax considerations were not front and center in, or actually considered in drafting of the bill. Our concern with drafting with the bill was providing a mechanism and a process to allow those companies which wish to incorporate as benefit companies a process to do that. It would ensure that directors would be able to, and under the benefit company legislation, they must act beyond just the fiduciary responsibility, and the benefit company legislation provides an avenue to do that. You know, I think to the member's question, I suspect what he's correct me if I'm wrong. What I suspect he's trying to get at here is, why do we need this legislation in Canada versus the United States? And you know, we know, Honourable Chair, that it's generally recognized that Canadian corporate law does not have a strict shareholder primacy that they have in the U.S. We recognize that. So directors of companies in Canada already have more discretion to pursue a broader mandate beyond maximizing shareholder values, profits. We recognize that. We also recognize that directors of ordinary companies are held to the standard of acting honestly and in good faith with a view to the best interests of the company. It's likely that this standard is sufficient right now to allow directors to consider other stakeholders beyond shareholders. We understand that. However, we've heard from many businesses operating in this space who choose to pursue a triple bottom line, that approach to business, that this legislation before us would help them feel secure in pursuing their mission. You know, for example, the legislation would provide a simple standardized framework for companies to adhere to that is legally and commercially recognized. It would provide clarity for directors and shareholders about the nature and mandate of the company and its goals. It would provide reassurance to individuals wishing to be directors of benefit companies that they are free to pursue the triple bottom line. And it would provide certainty for impact investors of the nature and mandate of the company. And finally, it would enable companies to attract capital while being true to their mission as they grow. And that's an important distinction from the C3s, which in British Columbia were brought forward as a fine piece of model, but it's a model that also has associated with an asset lock, which has precluded many impact investors for actually investing in said C3 companies. The legislation would also encourage more companies to pursue socially responsible and environmentally sustainable approaches to business, creating beneficial outcomes for society as a whole, and leveraging the power of business to help us tackle significant social and environmental change. So, you know, I hope that's addressing where the member's going.
Member.
It's more than addressing where I was going, but I'm happy to have that conversation at this point. Just to, when we had some of this discussion, of course, at second reading, but certainly, you know, we continue to hear in the community questions about the need for this particular legislation. And so to ask the question this way, in the description that the leader from the third party has talked about in terms of the need for this particular bill, when he looks at that list of items, what are the particular items that aren't already provided for under the Business Corporations Act in terms of corporations that are able to function with these good purposes in mind that isn't already provided under the current act?
Member.
So there's a rather extensive answer to this question because I think it's an important question, and I'll start by noting that it's important for us to recognize that Canadian law is distinct from U.S. law. The member has referred to B Corps, which is a U.S. third-party validating, third-party verifier. And we don't have the shareholder primacy concerns here in Canada that they have in the U.S. However, case law and case law in Canada has made it quite clear that directors of Canadian companies may consider other shareholders in their decision-making. This bill before us goes much further in that difference. It recognizes the difference. It holds directors of benefit companies to an even higher standard. Rather than saying directors may, directors of benefit companies must consider their impact on environment and on people affected by the company's conduct. And they must balance this duty with their traditional duty to the best interests of the company. That is a very important difference between existing law and what the benefit companies are doing. This would represent a novel and significant development in our law, and in light of the significant addition to the duties of the directors, we wanted to ensure that the directors are willing to take this extra step and aren't opening themselves up to substantially more liability by trying to do good. That's why we chose to provide these protections in the legislation. So the legislation is rather, it moves beyond existing legislation rather than it provides, reduces risk for those directors and companies that wish to move down into a triple bottom line approach. We've further consulted extensively with the BC branch of the Canadian Bar Association, and the lawyers who reviewed the legislation as part of this consultation did not actually raise the concerns that the member is suggesting. In fact, practicing lawyers who work with clients in this space, these are the ones in the field who are working with clients who've asked about this. They argued that the protections for the directors included in this legislation are critical because they have been recommending to their clients that they not actually go beyond the kind of fiduciary responsibility because of the additional risk that is being taken up. We sought to find a middle ground here between accountability and protection from directors. That's reflected in this legislation. And I will say, the member may refer to the rather well-known BCE case, and I will suggest that that case is the one that made it quite clear in case law in Canada that, in fact, directors may go and consider issues beyond the fiduciary responsibility. However, the federal government recently, in their Budget Measures Implementation Acts, actually codified this BCE legislation in the federal statute. So in our view, as I said, this is an important addition that is not covered under existing case law in the context of the broader bill.
Member.
So, I think we're in general agreement that there's good purposes to have companies act in a responsible and sustainable manner with the aims of what elements of what's described in public benefit. And certainly I can appreciate the reduction of director liability that is spelled out in this bill. And again, we will get to that section of the bill. But I think it's important, Mr. Chair, at the outset to understand the overall framing of the bill and the reason for it. And this is the reason why when I look at our Corporate Act, the Business Corporations Act, and the case law that surrounds that act and other similar legislation in this country, it obviously does not preclude companies from reporting on their environmental management, their impact on communities, and their local community activities, for example, in places in which they operate. So certainly, when you look at any annual report or any public disclosure required for any publicly traded company, you have that level of disclosure and measure around the aims of that corporation. What I'm hearing from the member, of course, is that the difference under this bill is that those particular aims are being spelled out specifically, and as a result, we need to lower director responsibility in terms of how they might be held accountable for meeting that public benefit. So I guess it does invite the conversation around what is the member's view on what is good corporate citizen behavior in this country, and that we have an expectation under our corporate statutes today that companies who are incorporated under the Business Corporations Act, corporations that don't get incorporated under this new act, if it passes, what is the expected standard of those companies to act in the same way that we might see for a benefit company?
Member.
Thank you. I appreciate the question. So first off, to clarify, this legislation does not affect the fiduciary responsibility of a director at all. There's no difference between a benefit company and any other company. However, in the case of the benefit component of the benefit company, the liability is reduced from a pecuniary one to one that is simply, what's the word I'm looking for? Injunctive relief. So what we're saying is, in the case of the benefit, the reduced liability is in the injunctive relief. To the member's case about we expect good corporate citizens in British Columbia, well, we might expect that, but the only way to test that is to go to court if you don't like a decision, and that would preclude the average person from actually taking that step. We have some examples where companies have wanted to actually stand up and do more. The recent example of Loblaws, for example. Shareholders rejected a proposal by Loblaws that wanted to talk about consider moving forward with a living wage. So shareholders very recently reject this proposal. So now Loblaws, if they were to introduce that, could open themselves up to a challenge because the shareholders rejected the proposal on a living wage. Had Loblaws incorporated as a benefit company, and in their benefits they had specifically stated articles that were there to ensure that their employers were treated in a particular fashion, then the protections would be there for their directors to actually introduce the living wage in their workforce without the fear of actually having a legal challenge to them that would lead to financial penalties. They could have injunctive relief sense. They could be told not to do that. But with the benefit company, with the benefit provisions there, it protects companies from doing what they want to do. The Loblaw example is a great counterexample to what happens when we don't give an avenue for companies to actually do the good they want to do because shareholders don't want them to do that. So while in theory, in the theoretical world, the notion that companies right now may do good if they wish, and the BCE ruling underpins that, and now federally in the federal government is moving through to enshrine that in their Budget Implementations Act. It's still an optional fashion, and we believe, and the fact that many companies came to us with this as an example of their frustration, we believe that it was critical to actually provide this opportunity to allow companies to actually move towards this kind of new approach. It is innovative. It's novel. It's been incorporated in a number of states, as the member alluded to, in the U.S., as well as Italy and a few other jurisdictions. And as we move forward, I think you'll see that the uptake is quite exciting.
Member.
And I think that, thank you, Mr. Chair. I think it's important to understand the distinction and the aims of this bill. It's also important to keep in mind the unintended consequences that might occur with some of the provisions of this bill, which we'll get to. But I think it's important to say that I would have thought that as members of the Legislative Assembly that we have every expectation that companies will meet many of the objectives of this bill, and they're able to do that. There is certainly, in terms of shareholder proposals under the Business Corporations Act, there is requirements for when a shareholder puts forward a proposal to a general meeting of shareholders for a company. That's something that, for good governance purposes, is necessary to set out in that set of protocols. But here, just to ensure that when we start playing with and adjusting the responsibilities of directors, and also how public benefit will be defined, which is in the public interest of this province, presumably. These are the areas of the bill that we'll be exploring, but I just wanted to at least have on the record that discussion to understand the general thinking behind this bill. So thank you for that.
Shall Section 1 pass?
Aye.
So ordered. Shall Section 2 pass? So ordered. Shall Section 3 pass? So ordered. Shall Section 4 pass? On Section 4, member from Vancouver-Langara.
So if I could invite the member to just walk through with us the requirements of where a benefit report will be maintained as per the provisions of the Business Corporations Act, Section 42, Sub 1, Q.2.
Member. Member.
Thank you, Honourable Chair. Section 46 of the Act is modified to add after number 4, which states any person may, without charge, inspect all of the records that a company is required to keep under Section 42, other than records referred to in Section 42, 1, bracket L, 2, bracket O, bracket, and bracket R, bracket, III bracket, if the company is a public company, a community contribution company, a financial institution, or pre-existing reporting company. That's subsection 4 of 40, it's 46 bracket 4 bracket. We're suggesting to add 46 bracket 4 bracket, actually bracket 4.1 bracket, which adds as well that a person may, without charge, inspect a copy of the benefit report that a benefit company is required to keep under Section 42.1. The location of keeping the records is no different from any other company.
Shall Section 4 pass? So ordered. On Section 5, member from Vancouver-Langara.
I first wanted to ask the question about the public benefit definition. It's been commented upon to us that this actually is a weaker definition than what's appearing under equivalent charity legislation with whether it's societies or others. Could the member comment on comparing this definition versus other similar definitions for charitable organizations?
Member.
Thank you. I'm going to ask the Minister after I've respond whether she has any additional insight. When we move beyond the immediate bill, it's a little more difficult without the depth of expertise to know how some things relate in other areas. I will say that what we did is we focus quite extensively on the Business Corporation Act, Section 51.91, which is Part 2.2, Community Contribution Companies. In that, there's a definition called community purpose, and for the purpose of, in there, it's defined as this. Community purpose means a purpose beneficial to A, society at large, or B, a segment of society that is broader than the group of persons who are related to the community contribution company, and includes, without limitation, a purpose of providing health, social, environmental, cultural, educational, or other services, but does not include any prescribed purpose. So we modeled our definition of benefits based on the definition of community purpose, as per the community contribution companies, the legislation of which was brought forward by the previous government. To continue, if I go to the, I must get to my bill here. With respect to the public benefit, here what we tried to do was we tried to be inclusive to ensure that we weren't prescriptive of exactly what that benefit would be, inclusive to allow a class of persons, as outlined here, as well as the environment. So it's broader, but it's modeled after the C3 legislation, and I'll take my place, and perhaps the Minister may supplement that.
Minister.
Thank you very much, Chair. Through you to the member. I think the definition is there. It's a broader definition. That's basically the difference. It's more expansive, a broader definition than the member was describing. So I wouldn't describe it in the way the member has described it. I would describe it as a more expansive, a broader definition.
Member.
Well, I guess the linkage on this would be, looking forward, will be something we consider under the same section. So I guess we can speak to it, is if we can jump back and forth, because Section 5 of the bill obviously has numerous subsections, which I certainly would like to go over. But just where public benefits is utilized under 51.993 sub A, sub little 2, for example, it says that the director or officer of a benefit company must act honestly in good faith with a view to, sub 2, promoting the public benefits specified in the company's articles. So was there consideration around the use of the word promoting as opposed to some other word that actually might reflect action?
Member.
Thank you. With respect to the word promote, that we did not seek alternate words for the word promote there. However, the key aspect of 51.9931 in our view is and the action is in B, where it states specifically that the director or officer of a benefit company must balance the duty under section 142(1)A with the duty under paragraph A of this subsection. So the balancing aspect is the action that we believe is needed.
Shall section 5 pass?
Well,
It's on section 5? Member?
yes, I think we'll be on Section 5 for some time, given the nature of the provisions that are all under Section 5. Maybe we could just speak to the balancing aspect there. So in terms of the way this was drafted, it appears that one reading of this provision may be that when you look at the actual section in the Corporations Act, under Section 142, Sub 1, Sub A, that sets out the requirements of how a director must act honestly and in good faith with a view to the best interest of the company. And as the member spoke to, best interest of the company has been really much thoroughly canvassed and defined under case law as to what that means in terms of a more expansive definition and interpretation. Sub B, exercise the care, diligence, and skill that a reasonably prudent individual would exercise in comparable circumstances. Act in accordance with this act and regulations, and subject to paragraphs A to C, act in accordance with the memorandum and articles of the company, which, of course, in the articles can state a specific set of purposes for which that company is incorporated. That exists today, I note. In terms of the sub B portion of 51.993, 1 sub B, as the member just mentioned, there is a language that says balance the duty. So if I could ask the member for how this provision with that lead-in language is intended to be interpreted, and does it qualify the existing standard of director responsibility under Section 142, Sub 1 of the Business Corporations Act?
Member.
Thank you very much, Honourable Chair, and thank you to the member for the question. So Section 142 of the Act, as the member noticed, says that, 1, a director or officer of a company, when exercising the powers and performing the functions of a director or officer of the company, as the case may be, must, A, act honestly and in good faith with a view to the best interests of the company. Stop there. Nothing in the bill changes B, C, or D in Section 142. However, what we've done here is say in Bill M209, 51.9931B, we've said here that one must balance what's in the best interest of the company, that's 142.1A, with the thing immediately above it. That is that the directors are expected to act honestly and in good faith with a view to conducting the business in a responsible and sustainable manner and promoting the public benefits specified in the company's articles. So this is the subtle difference, is that we are adding that section, which suggests that we're now saying that those two must be balanced with 142.1, which is the duty to act honestly and in good faith with a view to the best interests of the company. So we're extending this beyond just the company without touching the B, C, or D, which are the exercise, the care, diligence, and skill, etc., act in accordance with the Act, etc., and subject to paragraphs A to C, etc.
Member.
I just suggest with the drafting that's here, that the word balance may suggest that there is a greater priority where there may be some conflict with how a director is to meet their duties, whether it's duties to act in the best interest of the corporation or duties to promote the public benefits as set out in the company's articles, which would be an example of how we would fit those two provisions together. So let me ask, first of all, whether the member, in terms of the consultation, has received comment on this particular provision, because we certainly have received letters recently in the last few days about concerns around this particular provision, for example.
Member.
So I think to the member, through you, Honourable Chair, I think I would have received the same emails, because I believe the member and I were copied on the same emails. There were 3 people who contacted us who had very similar concerns. We had many others who contacted us who did not share those concerns. In this case, I think to the member, what we're trying to do here is we recognize the word balance is one that needs to be coupled with some more protection for directors, which is why we've added just the injunctive as opposed to monetary relief. We've, in the bill down in section 5 of 51.993, you'll see there it says, despite any rule of law to the contrary, a court may not order monetary damages in relation to any breach of subsection 1. So the reason why we've done that is because in the attempt to balance the best interests of the company with these promoting the public benefits and conducting the business in a responsible manner, we recognize that we want to protect directors who are trying to do that. And so injunctive relief is available to shareholders, but not monetary relief with respect to the benefit component of it. So we have received extensive feedback from a variety of people. This issue was raised by a couple. We disagreed with that, as did others.
Member.
Just to, I appreciate the view of the member in terms of the feedback he's received of concerns, and you know, I don't know that it's necessarily a numbers situation in terms of you know, greater quantity in favor versus against, so to speak, or concerns. I do recognize the concerns that have been shared with the member and myself and others, other colleagues in our BC Liberal caucus here. But I think the other way of coming at balance is actually to read this against 51.993 sub 3, which does speak specifically to this specific example I gave, because in each case it refers to section 142 sub 1 sub a of the Act, and that specifically explicitly says the director or officer of a benefit company does not contravene the duty under section 142 sub 1 sub a of the Act due only to the director acting in accordance with subsection 1 of this section. So I guess the way this is drafted, it does turn back in itself in the sense that you're not found to be in breach of that section of the Act, which is to act honestly and in good faith with a view to the best interests of the company, as long as you're balancing the purposes of promoting the public benefits specified in the company's articles with that particular duty. So it would suggest that in a situation where a director may be found not to have acted in the best interest of the company, that that director would not be in breach of what is a section of the Corporations Act, which applies to every other director for the companies that we spoke about earlier in this province, as long as that director was attempting to balance the other public benefits that are specified in the company's articles. So in my view, what that would suggest is that there is effectively a lowering of standard, let's say, because that director no longer has to meet what is set out in the Act in Section 142, Sub 1, Sub A. Is there a concern that the way this bill is been drafted and composed, that we're effectively enabling directors of benefit companies to meet a lower standard?
Minister.
Thank you very much, Chair, and through you to the member. So the Finance Ministry, as we've said, has gone through the bill and has taken a look at the clauses. And just to touch on this piece, certainly our interpretation is that you still have the duty to act in the best interests of the company. None of this changes that requirement is still there. And adding duties doesn't actually take away from that clause, doesn't take away from the requirement still to meet the best interests of the company. It adds the balance, I think, as the member has described. As he suggested, it talks about the balance, but it, in fact, in our interpretation from the Finance Ministry, it does not take away the requirement and the duty to still act in the best interests of the company. That still remains in the legislation, and that would be our interpretation.
Member for Oak Bay, Gorn Head.
Just to clarify, that is our interpretation as well, and I thank the minister for providing that.
Thank you. Recognize the member for Vancouver Langara.
Thank you, Mr. Chair. I did mention earlier that I will have a series of questions relating to Section 5 because they're quite encompassing in terms of the main nature of this bill. I appreciate the response from the Minister of Finance as well as the member. I would like to just come back then to Section 51 Sub 993 of Sub 3 of this bill under Section 5. So just on a plain reading of the words that are there in Sub 3, it does say that the director does not contravene the duties spelled out or the duty under Section 142 Sub 1 Sub A of the Act. So in what circumstances would a director acting in accordance with subsection 1 of this section be seen not to have contravened that particular section? What does that director need to do?
Member.
Thank you, Honourable Chair. I'm going to ask the Minister of Finance to provide some further clarification. But to address this first, I'd like to draw the member's attention to the 51993 number 3. The key words there are due only. So it says here, a benefit or officer of a benefit company does not contravene the duty under Section 141(1)(a) of this Act due only to the director or officer acting in accordance with subsection 1 of this section. So I'll give a specific example. Let's suppose, hypothetically, I'm Loblaws, and I decide that I would like, because I'm a benefit company, and in my articles I have an article that I believe it's important to pay living wages, and I believe it's important to treat employees in a certain way, and you have some articles to that regard. So the fact that I'm doing that means that, and that is a benefit as defined in 51993(1)(a), that by itself does not undermine my ability to act in good faith with a view of the best interests of the company. So that is essentially saying that if a director, due only to trying to apply the benefit as articulated in 51931A, 51.993(1)(a), due only to that, that in and of itself does not undermine the director's ability to act honestly and in good faith with a view to the best interest of the company. I think it's quite clear, and the key words are due only, and perhaps the Minister could expand on that.
Minister of Finance.
Thank you very much, Chair. Through you to the member, I think the key word, as the member has said, is only in this section from our read. I think it spells out that a shareholder wouldn't be able to sue a director claiming that focusing on the additional duties that have been put in, so the sustainable manner, et cetera, would mean that they had contravened their requirement to act in the best interest of the company. And I think the only identifies that. So it doesn't actually take away from the ability to act in the best interest of the company, and ensures, as I said, that claim can't be utilized. In fact, both duties, as we talked about in the previous discussion, both duties are required and are required to be balanced, as it says in that section.
Member.
Yeah, I mean, I think trying to work through examples would be helpful, and I appreciate the member raising one. I'm sure we can think of other examples. I think conceptually, I appreciate what the Minister of Finance is saying, that it's intended that effectively both duties are to be met. It just strikes me that the way this is being expressed, including in the response, that effectively you could have a situation where a director or a set of directors are not being found to be in breach of acting in the best interest of the corporation because they're more minded to promote the public benefits that are set out in the company's articles. So this gets back to the earlier discussion as to why do we need this bill in the first place, because really as we look at the expansive case law interpreting statutes like the Business Corporations Act, we see a more expansive definition of what the best interest of the corporation means. It doesn't just mean the shareholders. It does mean stakeholders, which includes employees, community members in which a company might operate. So it does extend beyond that. So I think the considerations that this bill is trying to address by framing it this way, there are concerns regarding how directors' liability effectively will be potentially watered down in order to meet this higher standard. But let me just go back to where we were in the definition section of Part 2.3, Section 5, which is around the public benefit definition itself. So when we deal with the environment section, sub B of this definition, were there other elements that were considered as part of this definition?
Member.
Thank you. The definitions were meant to be broad and inclusive, and at the front it says means a positive effect, including of an. So it's a very broad and inclusive. So we did not consider anything other than what was here, but we haven't precluded it only be that which is listed specifically, because we've allowed for some flexibility.
Member.
Just in terms of the definition of responsible and sustainable manner, sub A talks about taking into account the well-being of persons. What are the dimensions of that term well-being as used in this definition?
Member.
I'm sorry, I don't understand the question. Could the member please repeat it?
Asked another way, what does well-being mean in the course of this definition?
Minister.
Thank you very much, Chair, and through you to the member. So I'll just rise to speak on this because this was an area where feedback came from the Ministry of Finance. The term that was originally utilized was material well-being, and the recommendation from the suggestion from the Ministry of Finance was not to use the word material in defining material well-being, because material implies that there could be a level that matters and a level that doesn't. And so certainly from our perspective, using the term well-being referred to in the plain language ordinary term of well-being, which we felt covered off in this section. Using material well-being implied that there would be a measurement to show it mattered and a measurement to show it didn't. And so we felt well-being was a better description.
Member.
I appreciate the response in terms of material, and I can understand that. But in terms of the plain language interpretation of well-being, if I could just get, just for the record, a description of what's intended to be captured by the use of that wording in this definition.
Minister.
Thank you very much, Chair, through you to the members. So in statutory definitions, such as this piece of legislation, other pieces of legislation, we do use the plain language definition. That is the definition that is used. And so it purposefully, it provides the opportunity. But we're speaking about people here. And so it would include, the plain language definition would include good health, would include comfort, and would include security. So personal security, economic security, well-being of persons would include those three plain language definitions of well-being.
Member.
So I thank you for that response, and just moving to the next subsection of that definition, sub B refers to a fair and proportionate share of available environmental, social, and economic resources and capacities. So if I could ask the member through you, Mr. Chair, to explain what is intended to be captured within that section.
Minister.
Thank you very much, Chair, and through you to the members. So I think the important piece is that fair and proportional share doesn't stand by itself. Again, as we talked about linking clauses, it refers to, in fact, the responsible and sustainable manner. So it provides the context around the responsible and sustainable manner, those two pieces together.
Member.
Well, you know, I appreciate the aims and the objectives of the definition as being something to aspire to. It's curious to me though in terms of how a company will determine whether it's fair and proportionate share, because fairness and proportionate share suggests that it's fair and proportionate to others who are not under the purview of the company's operations. Of course, First Nations and Indigenous peoples comes to mind as to how you apportion environmental resources, for example, and economic resources. So I just wonder whether this has the benefit of a clear definition as to how companies will actually utilize this definition, and whether there is other similar legislation in the use of this term. Is there any similar legislation that would be of help in terms of interpretation under any other BC statute?
Member.
Thank you. We're not aware of any other such statutes that use such a term. The purpose of such a term in this definition here, the intention, of course, is to provide guidance to directors under their dual commitment, which they're supposed to exercise while through, as in section 142.1, to act honestly and in good faith to exercise their duty and responsibilities, to pursue specific benefits and operate responsibly and sustainably. While we're not aware of other, or my staff are not aware of other legislation, and I offer a pass to the Minister in case she has access to other information.
Minister.
Thank you very much, Chair, and through you to the member. No, not aware of other legislation, but I think similarly to the discussion we just had, I think again it's important to take a look at statutory definitions and the plain language view of those. So again, fair and proportionate share would be linked to, again, responsible and sustainable manner, so using resources that you need while recognizing resources for future generations, those kind of plain language approaches. But I think the other piece that's important in this section and around the definitions and how you interpret the definitions is the importance of the benefit report that will be issued by the company, because in fact the benefit report provides that accountability. If there is a different kind of interpretation used by a company, for example, that the shareholders may not agree with or the public may not agree with, they won't be investing then in that company. So there's an additional level of accountability that I think is important in this piece just to mention, which is the benefits report and the opportunity for the public, the shareholders and others to be able to see the action on these definitions and to see and interpret, to see the interpretation used, and then provide, as I said, their decision around investment and work with the company.
Member?
I appreciate the responses, Mr. Chair. I just, there's a reason why I'm focusing on this provision, of course, because it feeds into the section that we were talking about earlier, which is section 51.993, sub 1, sub A, sub little 1, which is the standard for benefit companies under this bill, that directors must act honestly and in good faith with a view to conducting the business in a responsible and sustainable manner. So this definition, of course, is instructive as to how a director or a board of directors will ensure that the company is meeting that standard. And I appreciate, to the minister's point, that there will be a benefit report, and we can work through what that will look like on an annual basis. But just coming back to this definition, on sub B, I think it's another good example of what does fair and proportionate share mean, because fairness, of course, is in the eye of the beholder at the time that the company is actually doing its operation, and in the issues around lowering our carbon footprint and other considerations around our environment, for example, what does that mean in this context? But the actual word that I don't know that I've seen also in legislation, perhaps I can just ask specifically about this word as well, is endeavors. So has that word endeavors been used under BC statutes as a test in terms of demonstrating what a responsible and sustainable manner ought to be?
Minister?
Thank you very much, Chair, and through you to the members. So just a quick search. We can find other acts to be able to provide to the member with a little more time, but just a quick search shows that it's often used in insurance contracts, but it's also used in legislation. It's been used in the NISCA final act and Manolf Treaty as well.
Member?
And so just hearing, I heard the second part of the answer, but the first part was insurance contracts?
Minister?
Thank you very much, Chair. Yes, insurance contracts, often used in insurance contracts.
Member?
Well, certainly, I can appreciate, in respect of agreements like with the Nishka, that there would be this kind of language utilized. I would suggest, though, in the context of this bill and in the context of director liability and duties, that the precision might be more accurate in terms of the test that's being utilized. So we've had the discussion on 51 sub 993 about the interplay, let's say, with section 142 sub 1 sub A. Here's another example, in my view, of what conducting the business in a responsible and sustainable manner will mean, because endeavors is basically like trying. It doesn't actually do that. So in the trade-off of ensuring that directors are meeting what is these higher level aspirational social good type goals under public benefit and responsible sustainable manner, there is a trade-off here in terms of again, we've had the discussion about potentially reducing the level of responsibility of directors to meet those new duties. But let me just go to another question here relating to third-party standard. So third-party standard as defined under this section 5 is talks about the overall performance of a benefit company, again in relation to its conducting business in a responsible, sustainable manner, and the performance of the benefit company in relation to the public benefits, as stated in the benefit company's articles. Particularly in respect of public benefit and the use of the definition responsible, sustainable manner, why is it the case that a third-party standard setting body is needed here?
Member.
Thank you. The reason why a third-party standard-setting body is incorporated is for transparency and accountability. We're hoping to avoid a company self-reporting on itself and to ensure that the standards are examined in a transparent and accountable manner by an independent third-party arm away from the close connections of the company.
Member.
And so the nature of a third-party standard setting body is a private entity. Is that correct?
Member.
A third-party standing-setting body means a person or entity that is not related to the company.
Member.
So just in terms of the nature of public benefit, when we're talking about issues relating to the environment, including air, land, water, flora, and fauna, and animal and fish and plant habitats, it would suggest that the determination of what public benefit would be in that area would be, of course, in another use of the term public interest. And so would it not be the case that the standard for defining and assessing and reporting on a public benefit would be best left with a public body which is of a governmental nature? Did the member consider that as being the body in which would deal with these standards?
Member?
Yes, and I appreciate the question. So the goal here and what we expect and hope will happen is, in fact, that we will see arise in a manner parallel to what happened when this previous government brought in the carbon neutral government legislation. What you saw emerge there were entities that were arm's length from government that were started to move down the path of developing offsets, and those offsets were held to high international standards. One of them, BC-based company Offsetters.ca, a very well-known company, picked up in the mid-2000s to the latter part of 2000s as a direct consequence of the previous government's efforts in this regard. So it doesn't preclude a public entity. It doesn't preclude a BC-based entity. At this particular juncture, we didn't want to be overly prescriptive, and there's room through regulation settings down the road to expand upon this.
Member?
Well, I think that we have regulators, of course, of companies, and so whether it's under particular regulations of government or, of course, the Securities Commission for public companies. And so when we're talking about directors' duties and how they're dealing with the investing public, for example, that it would be appropriate, of course, for that to be kept within government or some regulatory body of government. I'm curious about the member's suggestion that akin to under the carbon neutral tax that was provided by the previous government, that there would be actually organizations that might be struck to deal with this new benefit company. Could the member expand on how those entities would service this area?
Member?
So thank you to the member for the question. Under the carbon neutral government legislation, governments were required to be carbon neutral. They were required to offset anything above. Those offsets had to remain in British Columbia. The problem was there were not offsetting agencies in British Columbia to respond to the need, to the demand that was created by this carbon neutral government legislation. One of the things that emerged is such companies emerged in British Columbia to provide the service that the market was demanding. Those services provide third-party validation and accounting of carbon offsets. Offsetters.ca is one. What used to be used by Air Canada, I think it may still be used. It was an example of business responding to the needs of business created through government signal that was sent out to the market. I see no reason here why something different wouldn't emerge down the road in the province of British Columbia. With the province of Quebec talking about enabling benefit companies there too, we might see some partnerships with Quebec companies and BC companies, and we might see other provinces build on this, and as we move forward you might see nationwide companies emerge. Again, we were open to allowing, by framing it the way we did, we weren't prescriptive as it must be a particular third-party validator. We also know that the regulations will be set in place in the following months, and so feel quite comfortable with the way it's worded here.
Member?
Well, we've covered at the outset of this committee stage how novel benefit companies will be in Canada, and I think I'm hearing from the member that he anticipates that there may well be organizations struck to deal with, established to deal with this new type of entity in this province. And that I would say is quite concerning in the sense that I'm not sure why this government would look at shifting the regulatory oversight of corporations and investing public to these entities, which are not necessarily related to government and don't have the sort of rigor and experience under the various regulatory bodies that are provided oversight. So again, and perhaps I could ask the Minister of Finance for her comment as well on whether there's been any risk assessment from a regulatory perspective to have this standard setting being done by a third party as opposed to some government entity that, in my view, would be more appropriate.
Minister.
Thank you very much, Chair, and through you to the member. I appreciate the member's question. But in fact, this act in no way is shifting regulatory authority. The Business Corporations Act is in fact a facilitative act. So the entire act is facilitative. It provides an opportunity for companies to form. It gives companies the ability to form. There are other acts all across government that in fact govern everything from market conduct to consumer protection to environmental protections, et cetera. So I think that's the key here is this is a facilitative act. The requirements around regulation are in other acts to protect consumers, to ensure that market conduct is followed. So this provides the facilitative approach. And then certainly the check and balance that's in here is the third party reporting and the requirement around public reporting so that the public can then make their determination based on the public reporting that occurs and based on a third party assessment about whether this is a company they want to invest in or not. And that determination is there. So this again follows along the facilitative approach that the Business Corporations Act takes.
And I appreciate that given the nature of this bill, that there's a lot to think through here. And I appreciate the work that's gone into this as described by the member at the outset. I think as we walk through the bill, though, and hearing Minister of Finance's response, it raises a couple additional questions because of the nature of the standard-setting body. That body is responsible for determining includes the process used to develop a third-party standard, which is the criteria against which the benefit company's performance is to be measured and relative weight of those criteria. So you would think that that is an important role. And so the first point I would raise is that it feeds back into the ability of directors and officers to utilize 51.993 in terms of duties of directors and officers to effectively be a caveat on their performance on meeting the standard and duty set out in Section 142 sub 1 sub A of the Business Corporations Act. So as much as there are other regulatory bodies under other acts and statutes of the province that will deal with investor protection, for example. This body does play a very important role in setting the standard, and that is being delegated now under this bill to a third party, literally, because that's the definition, which does not have that regulatory authority or experience or connectivity, let's say, with a securities regulator. I use that by way of an example because this seems to be an outsourcing of responsibility in terms of setting up standards to a third party, which may not be related at all to government. So again, to the Minister of Finance, through you, Mr. Chair, does she not have concern about this delegation of authority out to a third party body, which may not be at all under the jurisdiction of government?
Minister.
Thank you very much, Chair, and through you to the member. So I think the first piece to start with is again to come back to the fact that this is a facilitative act. So if you were a company, not a benefit company, but a company, a corporation under this act, and you were looking at forming, government is not involved. Government now is not involved. So it's not that there's any less involvement by government with the benefit company. In fact, government is not involved. This is an enabling act. It provides an opportunity for companies to form. Government is not involved. That doesn't take away the requirement for directors to meet the best interests of the company, as we were talking about. That's there regardless. But there isn't a third-party standard. There isn't government who steps in and gets involved. So in fact, moving to you look at the amendments that are coming forward in the benefit company, in fact, there will be a standard. There will be a third-party standard. The company will take that standard, they'll apply it to themselves, and then the shareholders will make that judgment, just as they do with regular companies. When regular companies will report out each year, shareholders will make a decision about whether the directors have met the best interests of the shareholders, and they'll make a determination. That would be the similar with the benefit company. The additional piece that you have in this act is the third-party standard, an outside view, taking a look at whether these standards have been applied, and then again the shareholders will make a decision. So it's from that perspective, there is no involvement of government in either of those processes. So it's not that it's taken away anything. In fact, I would suggest that it adds an additional standard that is here for the benefit companies. And then I think the other piece is in the reporting out that happens, the benefit report, that includes why the selection of the third party was chosen. That has to be included as well. So there's additional accountability, again, around why the company was chosen to be able to set the standard by the benefit company. So that provides another level of accountability that's there.
Member?
Well, I continue to see a concern regarding how, as described, there's an interposition of a standard-setting body with referral under this bill, which is between, arguably, the Business Corporations Act as a framework, a legislative framework, and let's say a securities regulator who, for investor fraud or concerns from an investor about fraud, misrepresentation, might, or any other claim to court, might take the directors to court regarding some allegation of improper activity, not meeting the best interests of the corporation, and there being some out in this manner. But in any event, the standard setting is in between. This is further than what's in the Act currently, as the Minister just demonstrated or certainly outlined, and I understand that. But there is an additional standard here that is being interposed, as I mentioned. So if we go by way of analogy in terms of, just to share some of my thinking on this, if we look at securities regulatory law, for example, the Securities Commission certainly puts out policies and guidelines and standards which companies need to meet. For example, a 43101 technical report on a mining project is a standard with geoscientists and other technical support, a standard that public companies need to comply with. So that's an example where there is some involvement, but that's still under the purview of securities law and a public regulator. And so this standard, though, is not being reviewed by a regulatory body or provide any oversight in terms of the standards themselves. So let me ask that question that way, just so that I can confirm my understanding. Is there any oversight to these third-party standard-setting bodies by any regulatory body of government?
Minister.
Thank you very much, Chair, through you to the members. So I think the piece that's important to note, and I mentioned it earlier, but I think it's important to note again, is that standards are different than the regulatory acts. The regulatory acts that are in place right now for corporations, whether you're a benefit corporation, whether you're a business corporation, still have to be followed. None of that changes with the amendments that are in here. You will still have to report to BC Securities Commission. You will still have to make sure that you're following market conduct, the requirements legally in other acts around consumer protection, around securities. All of those still have to be followed. None of that changes with any of the amendments that are in here. The standards, again, set by a third party, the government will not be involved in that process. That's, again, private sector, as the private sector does with companies, making determination with shareholders about whether they meet the requirements. That will be a determination for shareholders to make, just as it is now with existing companies.
Member.
So just so I can appreciate that analogy, can the minister just provide an example of what she was just referring to at the end of her comments regarding a private body setting similar standards for private companies?
Minister.
Chair, well, two examples just off the top of my head. We can provide more to the member if he's interested, but with lead standard and fair trade would be two examples where, again, there's a determination from the outside, from the private sector, around what those standards look like. And many companies will, again, call themselves fair trade or will make a determination based on those private standards that are set.
Member.
And so I come back to the example with that in mind of this act. And the public benefit definition does contain elements relating to the environment. So is it not the case, though, that when we're talking about enabling benefit companies to operate for the public benefit and in a responsible, sustainable manner, and we're talking about concepts around using a fair and proportionate share of available environmental, social, and economic resources and capacities, that really the appropriate body that should be determining that is a public body that knows what the public interest is to be defined as, so that we don't effectively put this out to standards being set for public benefit, which will make it difficult, I think, for a court to deal with in terms of the interpretation of those standards, when really it should be government that's setting those standards.
Member, is there a question there, member?
Well, I'm just inviting for another comment about whether there's concerns regarding how a court will interpret the standard when it's set by a private body.
Member.
While the minister is looking here, I would draw to the attention of the member, we have section 16 in here that also gives rather well, it gives government power through order in council regulation, making power to actually address the issue of standard as well. Were there to be wrinkles moving forward, and I'll let the minister continue forward with a more detailed response.
Minister.
Thank you very much, Chair, through you to the members. So I think I think there, again, I'll go back to the facilitative approach versus the existing acts that are in place. Government's job is to ensure, as I talked about, consumer protection, market conduct, strong regulatory structures in place for how people act and do business in our province. And those pieces are in place. That's government's role, is to ensure that we look at consumer protection, that we look at environmental regulations, that we look at market conduct, that we ensure strong regulatory structure in our province so that people are acting in a way that is fair and responsible to the public. What we're talking about here are individuals' investments in private sector companies, and shareholders will determine, based on their investments or not, whether a company is meeting the goals that they want as part of their investment. We're ensuring that they're doing it in a way that is responsible, that follows regulatory structures, that whether we're talking about the BC Securities Commission or otherwise, that those pieces are in place. But it is shareholders who then will determine, as they do now in other examples, whether the company is meeting their goals. We set the accountability, as you can see in this act, accountability around ensuring the public has that information, that they have to report publicly, that requirement is there, so public has the information to be able to make those judgment calls.
Member.
I appreciate the response, and I appreciate the member's point as well about Section 16. Let me come at this. I think we have time for one more question at this point, but I think we've covered a lot of ground here. Just let me come at it this way. In terms of the benefit report under Section 51.994, under Section 5 here, is there any review contemplated of the benefit reports as they may be filed by government?
Member.
May I ask the member to please repeat the question? I was conferring with the minister and I missed that.
No worries.
Yeah, member.
Just specifically, the question is to Section 51.994, relation to benefit reports. Is there any government oversight in terms of the review of these benefit reports as they may be filed?
Member?
Your Honourable Chair, there's no requirement for government to be involved. This is about directors reporting out to shareholders their ability and progress towards the third-party standards. At this juncture, Honourable Chair, I move that the committee rise, report progress, and ask leave to sit again.